Concealed carry reciprocity is a frequent hot-button issue, both in the Second Amendment community and those who oppose it. And the National Fraternal Order of Police and the International Association of Chiefs of Police are opposing it. Let's look at both sides of this story, next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Nothing like poking a Second Amendment bear to get a lot of response out of people, so I'm expecting some interesting feedback on this. The question of not just concealed carry, but the reciprocity between the states. It's an issue I've dealt with as long as I've been carrying a firearm, and it's one I still deal with today. Before we get into this, I want to remind you the article is available on the website constitutionstudy.com, and you can also find the links to all of my sources that I used when I wrote the article. Now, stick with us. We're going to look at this Concealed Carry Reciprocity Act. For those of you who may not be familiar with the issue of reciprocity, let me describe it briefly. Many states attempt to regulate the Second Amendment by placing restriction on a person's right to keep and bear arms. One of them is the requirement to get a license from the state in order to exercise that right. Now, these licenses are only inherently meaningful within the state that issued the license. However, many states have come to reciprocity agreements where two states agree to recognize the other's carry licenses. The unwillingness of some states to recognize other states, and in some cases any states, carry license, is a direct violation of the full faith and credit clause in Article 4, Section 1 of the Constitution, which reads, "Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state." The framers of the Constitution provided a solution to this disagreement, again, from the full faith and credit clause. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. While Congress has tried several times to restore both the Second Amendment and the full faith and credit clause in regards to carry licenses, so far they've failed. Enter the Constitutional Concealed Carry Reciprocity Act of 2025. In a letter from the National Fraternal Order of Police, or FOP, and the International Association of Chiefs of Police, the IACP, both these organizations urge Congress to reject bill over major changes on officer liability and qualified immunity. Let's look at the legislation and the arguments against it. The FOP and IACP start with some powerful claims. The legislation exempts any person with a valid photographic identification from state or local firearms law who asserts that they are lawfully carrying a firearm under the laws of their own state of residence. Is that true? Would an out-of-state person with a valid photo ID be exempt from state and federal firearms laws? Well, reading from the law, we find, notwithstanding any provision of a law of any state or political subdivision thereof, except as provided in subsection B and subject only to the requirements of this section, a person who is not prohibited by federal law from possessing, transporting, shipping, or receiving a firearm, who is carrying a valid identification document containing a photograph of the person, and who is carrying a valid license or permit which is issued pursuant to the law of a state and which permits the person to carry a concealed firearm or is entitled to carry a concealed firearm in the state in which the person resides, may possess or carry a concealed handgun other than a machine gun or destructive device that has been shipped or transported in interstate or foreign commerce in any state that has a statute under which residents of the state may apply for a license or permit to carry a concealed firearm, or does not prohibit the carrying of concealed firearms by residents of the state for lawful purposes. So the first claim of the FOP and IACP is patently false. Not only does a person have to be carrying a valid photo ID, but they must also either be carrying a valid carry license or permit from their state of residence. If the person lives in a state that does not require a license to carry, then only a valid photo ID from that state would be required. This legislation goes on to state, this section shall not be construed to supersede or limit the laws of any state that permit private persons or entities to prohibit or restrict the possession of concealed firearms on their property, or prohibit or restrict the possession of firearms on any state or local government property, installation, building, or base. So this law does not exempt people from state and local firearm laws, but only that the state recognize a valid license from another state. The FOP and IACP go on. This is problematic, but the most concerning provision of H.R. 38 is that it prohibits law enforcement officers from making any arrest or detaining the suspect for any violation of state or local law pertaining to the possession, transportation, or carriage of a firearm. This also includes several federal laws such as carriage in school zones and federally managed lands. Again, that statement is factually wrong. In addition to what I've already quoted about state and local laws regarding prohibitions on private and government property, the legislation clearly states a person who carries or possesses a concealed handgun in accordance with subsection A and B may not be arrested or otherwise detained for violations of any law or rule or regulation of a state or any political subdivision thereof related to the possession, transportation, or carry of a firearm unless there is probable cause to believe that the person is doing so in a manner not provided for by this section. Presentation of a facially valid document as specified in subsection A is prima facie evidence that the individual has a license or permit as required by this section. State and local law enforcement are free to detain and arrest people for violations of their firearm laws, just not for the possession, transportation, or carrying, because they must assume that an out-of-state resident who provides a facially valid document that they are legal to carry in their home state must be honored by all states. This is a clear application of the full faith and credit clause. Furthermore, law enforcement officers can still detain or arrest someone for the possession, transportation, or carrying of a firearm. They just need probable cause the person is doing so in violation of the legislation. The FOP's letter goes on. Many states already recognize concealed carry permits from jurisdictions with comparable requirements, such as live training and enhanced background checks. These agreements respect state sovereignty and public safety without federal overreach. This legislation would override these tailored arrangements and strip states of their ability to set and enforce their own standards for concealed carry. Instead of officers being thoroughly trained on their state and local gun safety laws, officers would be expected to interpret any law from all 50 states in real time without reliable means to verify an individual's eligibility to carry concealed weapons, especially those from permitless carry states where no physical permit exists. State sovereignty is important, but it does not supersede the Constitution of the United States, which clearly states that each state must recognize the public acts, records, and proceedings of other states. It is also quite clear that Congress may provide both the manner and effects of those acts, recordings, and proceedings. Furthermore, I find this claim of law enforcement officers having to interpret and apply laws from all 50 states nonsensical. The officer already needs to know what state licenses they need to respect and be able to recognize valid licenses from those states. The FOP and IACP also seem concerned about the officer's precious qualified immunity. The bill goes further and provides that any person who is deprived of any right, privilege, or immunity may sue a law enforcement officer who would not be afforded qualified immunity. This makes it impossible for any officer to conduct any investigation with respect to ascertaining if the person is in fact compliant with the firearms laws in their state of residence. It would also expose the officer to civil liability if, for example, they were to secure the firearm while they conducted an investigation into other suspected criminal activity. This is another example of how law enforcement uses their vaunted qualified immunity to infringe on the rights of others with impunity. Look at what the legislation actually says. A person who is deprived of any right, privilege, or immunity secured by this section, under color of any statute, ordinance, regulation, custom, or usage of any state or any political subdivision thereof, may bring an action in appropriate court against any other person, including a state or political subdivision thereof, who causes the person to be subject to the deprivation for damages and appropriate relief. The court shall award a plaintiff prevailing in an action brought under paragraph 1 damages and such other relief as the court deems appropriate, including a reasonable attorney's fee. If law enforcement officers deprive someone of a right secured by this legislation, they can be sued. Is that such a crazy idea? According to the FOP and IACP, even if you present a facially valid carry permit from your state of residence, you are considered guilty until they can prove that you are innocent. But that is not the way jurisprudence is supposed to work in this country. You are innocent until proven guilty. And if the documentation you provide is facially valid, meaning on its face it looks valid, and it's presumed to be valid, the law enforcement has no reasonable, articulable suspicion that you are committing a crime. According to the Supreme Court case Terry versus Ohio, in justifying the particular intrusion, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant the intrusion. Generally referred to as reasonable articulable suspicion, or RAS, that the subject has, is, or is about to participate in a crime. This RAS is required by all law enforcement in all situations outside of a warrant to detain or search a person. In effect, the FOP and IACP are arguing that law enforcement needs to be exempt from the restrictions of the Fourth Amendment and any consequences for their violations. This is confirmed later in the letter where we find the bill also seems to cancel any qualified immunity for the officers, as the right of Americans to keep and bear arms is guaranteed by the Second Amendment. Qualified immunity protects officers from civil liability unless they violate clearly established statutory or constitutional rights. Any action the officer may take in reaction to the knowledge that the person they have encountered is armed could place that officer in very real legal peril. Apparently, the FOP and IACP forgot that not only is the Constitution, of which the Second Amendment is a part, the supreme law of the land, but that each and every law enforcement officer they allege to represent took an oath where they swore or affirmed to support it. As the letter points out, the right of Americans to keep and bear arms is guaranteed by the Second Amendment. This legislation clearly recognizes that right, meaning any officer who violates that right is not covered by qualified immunity. It's almost as if the FOP and IACP don't want their law enforcement officers to be held to the same laws they enforce on others. Officers would be expected to interpret and apply laws from all 50 states in real time without reliable means to verify an individual's eligibility to carry concealed weapons, especially those from permitless carry states where no physical permit exists. This leaves law enforcement unable to confirm lawful possession during encounters, creating confusion and heightening risk in high-stakes situations. However, officers are not expected to interpret laws from any other state, merely to assume that if someone presents a facially valid license, they treat it as a valid license in their state. As things are today, not only do gun owners need to know and interpret the laws from any of the 50 states they wish to visit, but know whether or not that state currently respects their carry permit and the rules by which they do so. Again, it appears the FOP and IACP don't think their officers should be required to follow the laws that we do. Although not mentioned in the FOP and IACP letter, there is an interesting aspect to this legislation I find important. When a person asserts this section as a defense in a criminal proceeding, the prosecution shall bear the burden of proving, beyond a reasonable doubt, that the conduct of the person did not satisfy the conditions set forth in subsections A and B. When a person successfully asserts this section as a defense in a criminal proceeding, the court shall award the prevailing defendant a reasonable attorney's fee. This legislation reinforced another central tenet of the United States jurisprudence, the burden of proof. If someone from outside of a state is arrested and tried for carrying without a license, the burden of proof rests on the prosecution, not the defense. In other words, that person doesn't need to prove they can legally carry in their state of residence. The prosecution must prove that they do not only beyond a reasonable doubt, but before they arrested the person in the first place. In other words, the individual is assumed innocent until proven guilty and is at liberty until law enforcement can show they have probable cause that the person has broken the law. What can we conclude from what we've reviewed so far? Well, first off, the FOP and IACP claim to support your rights. It's quite apparent they do not. While the FOP and IACP support the Second Amendment and respect the rights of lawful, responsible gun ownership, the specific provisions of H.R. 38 present serious concerns for law enforcement officers. The bill's creation of personal liability for officers, combined with its erosion of state and local authority to regulate firearms and conduct reasonable investigations of armed suspects, threatens officers' safety and exposes agencies and officers to costly litigation. They claim to respect the Second Amendment, but would deny citizens of other states their right to keep and bear arms while in their state. That doesn't support the Second Amendment. They claim to respect the rights of lawful and responsible gun ownership, but not for citizens of other states. That violates the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." They also claim that this legislation creates personal liability for officers, missing the fact that what it does is remove the question of immunity for violating the rights of others. Overall, I think this is a pretty good piece of legislation. It may finally relieve American gun owners of what the FOP and IACP letter claims this legislation imposes on their officers: the need to know and interpret the gun laws in all 50 states. The FOP and IACP claim to represent a majority of rank-and-file officers and police executives, but are they representing their positions with this letter? I wonder, why would officers not want reciprocity for their carry permits? Oh, wait. As law enforcement officers, they already have reciprocity, not only with all 50 states, but in federal territories as well. I guess they just don't want you and me to have the same reciprocity. Anyone else recognize that the Second Amendment is the only rights protected that you need permission from a state to actually exercise? Anyone else surprised that a state will recognize their own permits but not other state permits, as if they don't really exist? Anyone else surprised that they're not happy that the federal government says, no, the same way you recognize driver's licenses, you must recognize carry licenses? And oh my God, qualified immunity. I mean, we won't be able to violate the rights of other people without being protected by the courts? How dare we? That's what the FOP and IACP are saying. I'm curious what you have to say. I'm actually going to send this to a couple of sheriffs I know and see what they think about it. Maybe if I get some good feedback, I'll talk about it on the radio program or something. But it's important to recognize the law. As a responsible gun owner, it's important to recognize whether or not where you travel recognizes your carry license. If this legislation passes Congress and gets signed by the president, it means that's one step we won't have to worry about. We still have to follow state law. They'll just recognize our license. And really, is that big an ask? And again, if you'd like to find out more about what we're doing here, head to the website, constitutionstudy.com. You can go to the store and maybe purchase a book or a t-shirt or something, maybe a nice Christmas gift. That helps support the work that we're doing. Of course, you can just donate to the cause. That's always great. There's a donate page as well, where you can make a one-time or recurring donation. But mostly what I want you to do is to share this information. Let other people know this information is out here, and use the research I've done to help protect yourself, your rights, and those of your family. And who knows, maybe if you share this with your friends and family and neighbors, most of you will come back and join us here next time for the Constitution Study.
Love the neighbors and have a few good friends.